We're here in, let me get my notes here. We're here in our case 1CACR 18-0356, Taylor versus Hernandez. Each side will have 20 minutes to argue their case. Counsel, you can save as much time as you like for rebuttal, but it's up to you to keep track of your time. We have a clock at the podium to help you keep track. We are recording the argument, so when you come to the podium to argue, please identify your client and yourself so that we can keep track of that. We're in a couple of days, the argument will be on YouTube, so you'll be able to see how well you did. We've read the briefs, we've looked at the record, we've conferenced the case. We're familiar with the issues and the record. So when you begin the argument, just launch right into what you want us to know and to talk about with us. Counselor, you may begin.
Good morning, and may it please the court. My name is Joshua Cordova. I represent the appellant, Mr. Francisco Hernandez CR2. He's not with us today. He's being housed at the Arizona Department of Corrections currently. I would like to reserve some time for rebuttal. I don't know how much yet, but I will watch the clock for that. There are two issues that appellant has briefed, as well as the appellee, and I believe the issue that I would like to talk about today is in regards to the invocation of the right to remain silent. The reason why I believe this is an important issue at this time is because there's two things that might need to be looked at in order to understand whether there was actually an invocation, whether it was unambiguous, and whether it was to be understood by the reasonable officer. Now, the exchange that I'm going to be discussing, as I noted in my reply brief, is going to be the third exchange, because initially in the briefs there was 3 exchanges where we indicated that there was a unambiguous right to remain silent given by the appellant. However, the exchange that I'm going to be focusing on today is the third exchange, and it was as follows. Appellant, my right to remain silent. Investigator Guerra indicated, is that what you want to do, referencing the right to remain silent? Appellant said, Investigator Guerra said, you don't want to say anything. And the reason why this is important, and it was so focused on in the reply brief, is because that exchange itself, with the rule in Feinhout, where it says that there could be clarifying questions in regards to an invocation of the right to remain silent, these are clarifying questions. There was 3 invocations, 2 before this third, that indicated that he wanted to remain silent. So when we get to the third invocation, this clarifying question is the first question Investigator Guerra asks, because it says, my right to remain silent, first clarifying question, which is allowed. Is that what you want to do?
Let me ask you, I presume seconds later, because I'm looking at the transcript. What you're reading is entry 29 and 30. At entry 35, the detective asks the following questions. But I'm asking you if you're willing to answer questions. Your client says yes. Is that relevant? I don't know how many seconds afterwards.
And it could have been slightly after, Your Honor, but the way the rule is interpreted in Feinhout, and it indicates that if, however, it is determined that an appellant's initial invocation was ambiguous, officers may ask questions designed solely to clarify whether the defendant intended to invoke his right to remain silent. We're indicating that that first question he asked was a clarification question. The rule permits clarification, and this is in one of the cases that says not questions that, though clothed in a guise of clarification, are designed to or operate to delay, confuse, or burden the suspect in his assertion of his rights, or in his assertion of rights, I apologize.
So you're saying, I guess, number 26, well to remain silent, right? And I suppose, is that, who says that? Is that
That would be the appellant, Your Honor.
that's the appellant? Okay, so that's preceded by, you have the right to remain silent, or you can make which of what comment you wish, or answer questions if you wish, or you can request an attorney. All right? And the response from your client is, well, to remain silent, right? And then the detective says, excuse me? And then your client says, is that my M dash, my to remain silent? So that right there is your invocation.
That is the main invocation, the clearest invocation that we're regarding. And
So in response to the question, excuse me, my dash to remain silent is an unambiguous invocation of one's right to counsel.
And that's what we are arguing, Your Honor. As it's indicated in Miranda, it says, in any manner, at any time, during or prior to or during questioning, if there's an invocation, it needs to be scrupulously honored. And that's the argument here, that it wasn't honored. The idea of the...
But it's gotta be an unequivocal statement, and I'm having difficulty finding that here.
Well, and Your Honor, and the reason why we're focusing on the third exchange is because there was 2 prior exchanges that involved my right to remain silent. Now, the transcripts indicate in the motion to suppress transcripts, when defense counsel put their expert that transcribed from Spanish to English, they focused on what the right meant with the question mark in one of the earlier invocations. What they had indicated was that that was a way of speaking, that was just a way that it may be cultural, but the way it would have been in English is, right, asking for clarification, my right to remain silent, right? And the way it was said in the Spanish, there was a no at the end. The no is a way that was translated saying that, well, that cultural difference in the English spoken language would have been right. So because there was 2 times where this invocation was given, and the third time the more clear one, that's why the investigator Guerra went with clarification questions.
Now, what's our standard of review when we look at this issue? We're now making the determination in the first instance, de novo, whether that's unequivocal, are we, or are we?
I think it's de novo for that reason, that it's a mixture of law and fact, because it was in fact involved a constitutional issue, the right to remain silent.
But I think Judge Howe is asking, when you have what you're raising, which is parsing a transcript, ink on a page, whether or not we have to view the trial court's take or interpretation of that document in the light most favorable to upholding the court's ruling.
And that is the standard, Your Honor. In addition to that, it says that you're going to be ruling on a motion to suppress for clear and manifest error. And they also indicated that in State v. Jones, that clear and manifest error is abuse of discretion. Now, that's the decision that the trial court made.
So you agree with that? We have to review the facts in the light most favorable to upholding the court's ruling.
And I do agree with that, Your Honor.
We move to the transcript, and the error is egregious enough, like your client is arguing, that it overcomes that deference.
I do argue that, Your Honor, and this is why. In the transcript from the motion to suppress, there was the interview of Mr. Hernandez Serrano was submitted to the court. It wasn't admitted at that time. It was admitted later on in the trial, and it was testified to. And this is where his statements came in. But the reason why this is important is because the trial judge took that audio back and reviewed it himself, along with the transcripts.
Let me ask you, is that, so we're limited to the suppression here, right?
Correct, in regards to this issue.
Can we listen to that? If the judge didn't in open court listen to that hearing, that tape of the interrogation, but he just sort of says, just so you all know, backstage, I listened. Can we listen to it?
I would argue that you can, Your Honor. It's part of the record that came out that he listened to it. He also put in his ruling that he reviewed the audio and determined, and he also indicated that the reason...
When you say, you mean of the initial interview?
Correct.
Okay.
We're discussing the interview of Mr. Hernandez Serrano. The trial court asked for the CD, took it under advisement, went and reviewed the CD, the audio interview, came back, and when he made a ruling, he indicated on the record that he reviewed the CD along with the transcripts or whatever argument was made, and then issued a ruling.
Do
and
we
the
have
reason
that in our record, this audio?
we do, Your Honor, and I believe it's Exhibit 464, if I'm correct, 65. It's one of the last ones that were admitted onto the record. And the reason why this is so important is because along with that exchange in reviewing that audio, it's a split second from may remain silent. Is that what you want to do? You don't want to say anything? And it's that conversation where even the response from the investigator shows that he understood. He's asking for...
What was the answer to that last question? You don't want to say anything.
I believe it was, I don't know what you're asking, or I don't know.
Well, I think it's what would I say if I don't know anything?
Correct.
Which seemed to be an ongoing conversation rather than, look, I told you I don't want to say anything.
Correct. But this is why that rule is so important, because that's where we would argue that that's no longer clarification questions. That's going into keeping the suspect talking, to uphold his rights to remain silent.
Well,
they constitute unlawful interrogation. That would be not permissible clarification.
Well, if the detective or the officer has the right to ask for the right to ask clarifying questions, he has the right to respond to whatever the answer to the clarifying question is.
Correct, Your Honor.
So he can't, I mean, he gets to talk to the person if it's still unclear.
And I would agree there could be additional questions, but the reason why we're arguing that there shouldn't have been in this instance is because that initial clarification question was clear that once he said yes to a response to, is that what you want to do? He gave an and that's why today we need to understand what means. And should the officer have understood what means? Because if in fact is an affirmative, as the Supreme Court has issued a rule that I did submit in our reply brief, although it's not precedent, it's an idea of what even the tribunals would understand their interpretation of
So when Mr. Hernandez said then that was it. I mean, you said that he properly could go ahead and ask a clarifying question, but that doesn't seem like what you're arguing now. That once the defendant said that was it.
Correct. It should have been scrupulously honored that he invoked his right to remain silent.
What do you think is clear? Or yes?
I think yes is clear, but the way that the courts have treated is an affirmative. And the way that society has taught us what means would tend to prove that a reasonable officer would understand that is an affirmative.
So if we have a yes seconds after the but we're not allowed to consider that because the was clear, right? Because we do have a yes seconds after, but I'm asking you if you're willing to answer questions. Your client, yes. But that's not fair game because the was like a timeout.
That
And
the argument would be that at that time, yes, Your Honor, that it should have been scrupulously honored at that point that the right to remain silent was given and he wanted to invoke it, and therefore questioning should have ceased. The only other way he could have come back is like in Michigan v. Mosley. There could have been some time off, and this is a case that could have occurred that way because there was 2 cases that the appellant had, and they even started questioning him about the initial case prior to the case that we're at hand today. So that could have been an instance where they could have done that if it was scrupulously honored.
So, what's the authority for the fact that is unequivocally an invocation?
And that's why we're here today, Your Honor, because I don't believe there is any authority, and we'd be asking that.
I mean, it seems that the non-word responses could be interpreted different ways depending on the circumstances. And if that's the case, then the trial judge is in the best position to take evidence about what the circumstances were, what was the inflection of the
and if I,
which we can't do.
and I think you can, Your Honor, because I think you can review the record, especially in this record. There's ahas peppered in the whole record. And the way they're interpreted by this trial court, they're affirmatives. There's no clarification. Is that a yes? Is that a no? There's none of that. But there's just the next question.
Well, if the trial court found was unequivocally a yes, then why was it why was it not suppressed?
Because in this instance, in the suppression motion, it wasn't. That's why we're arguing that it should have been because there's like we've submitted in our reply brief, there's a manual that was created by the Supreme Court of Arizona, and this is to the transcribers that are in court, listening to testimony, listening to everything, taking a record of everything. They're supposed to put an affirmative next to the word That's one way of at least saying that the Supreme Court of Arizona saw so frequent the word used that they decided they needed to come together to make a determination if we should decide whether this word meant something.
The trial court heard the recording.
Correct, Your Honor.
Heard Mr. Hernandez said
Correct.
He had no choice but to determine that he said and we know ahas are always yes. I don't care what the circumstances are. If he says that's a yes, and I'm done.
I don't know whether he's saying yes when the other ahas were in the record, but I'm saying the way that the court interpreted ahas throughout the trial, they were, if read, they're interpreted as affirmatives. And that's what our argument is. If they're interpreted as affirmatives, if society sees as affirmative, as a yes, and that's why our reply brief focused on that so much. The definitions of what does mean? And this is the best way I can give it. Because if we're all society, if we're all on different levels because of education, because of experience, if we're all level at one point, which would make us lay people, we all have grown up understanding that is an affirmative.
So let me ask you, counsel, before you finish your time, what about the language barrier? Or do we consider that might be something more unequivocal, given that this wasn't your client's first language? How does that color your argument?
I think and as one definition in the reply brief indicates, it's from Spanish Dick. It's a website for Spanish language. It indicates it would be It's still I think is universal. Everybody knows
right, but do we account for the fact that your client, I think the case you cited said, doesn't use Oxford.
Correct.
Something doesn't isn't learned in the fine points of English, and so we shouldn't expect maybe as definite an invocation from him as from somebody else? Is there a case that says that?
I'm not aware of a case, Your Honor, but I think if you take that same idea and you place it to what we've all learned about that could occur. There could be an instance where there's a language barrier, but the fact that he's saying and shaking his head slightly as viewed in the video, it's clear that he's saying yes to may remain silent. And I would like to, if there's no further questions at this time, my remaining time for rebuttal.
Surely, counsel.
Good morning. May it please this court, my name is Nicholas Chapman Hushik, and I represent the state in this case. The issue in this case is not how someone may have defined or interpreted a certain term or expression. The issue is whether a reasonable officer, under the totality of the circumstances, could have believed that Hernandez Serrano did not unequivocally invoke his right to remain silent. The evidence from the suppression hearing, viewed in the light most favorable to upholding the trial court's ruling, shows that such an officer could have done so. Hernandez Serrano's
Could
claim
have done so what? Could have interpreted as an invocation?
could have believed that Hernandez Serrano did not unequivocally
Okay.
invoke his right to remain silent. Hernandez Serrano's claim to the contrary rests on three of his remarks during his interview with Sergeant G. First, after Sergeant G informed him that he had the right to remain silent, Hernandez Serrano asked, "May I remain silent or no?" To verify whether Hernandez Serrano actually wanted to remain silent, Sergeant G responded with, "Pardon?" Second, in reply, Hernandez Serrano said something to the effect of, "Silent?" He looked at Sergeant G and sounded like he was asking a question. In making both of these remarks, Hernandez Serrano did not unequivocally invoke his right to remain silent. Rather, he was asking whether he could remain silent. Now, as to his third remark, in reply to his second remark, Sergeant G asked, "Well, is that what you want to do?" And Hernandez Serrano responded with, "Uh-huh." In context, he still did not unequivocally invoke his right to remain silent. For one thing, the term "uh-huh" is inherently ambiguous. Moreover,
So, doesn't always mean yes.
no, Your Honor, and the Merriam-Webster dictionary even says that the term "uh-huh" may be used to acknowledge someone to continue speaking. And even here, Sergeant G, during the suppression hearing, interpreted the term "uh-huh." He testified, "The way he gave me that, I felt that he wasn't truly understanding what I was conveying to him, so he clarified that."
And so, what the meant was up to, at least in the first instance, for the trial court to determine.
It was up to the trial court to weigh Sergeant G's testimony, and this court should infer that the trial court found Sergeant G's testimony credible and should defer to that credibility assessment.
So, I understand where Merriam-Webster defines as a space filler, effectively, is what you're saying, right?
Correct.
Continue rather than an affirmative yes. Now, if you look throughout this transcript, though, the appellant uses two different words, and I have heard it, but one of them is but then he often says MMHM. Might that, do we account for that? Well, that looks like there's 7 of those, so that's how this appellant fills space or encourages further communication, which is very different from the 2 times in which appellant says which are in response to questions, unlike the mhms, which are in response to statements.
No, Your Honor, because we still have to look at how Sergeant G interpreted the and the fact that Hernandez Serrano did not testify to confirm what he believed to mean. And this court should defer to the trial court's credibility assessment of Sergeant G. Besides, Sergeant G was qualified to interpret Hernandez Serrano's remarks during the interview. He is a native Spanish speaker whose first language was Spanish growing up. He is a former designated interpreter of a local medical center. He even testified that he knows how to place meanings to words based on the speaker's dialect, accent, location, and education. Moreover,
He also conceded that this wasn't this wasn't the easiest conversation, that there seemed to be some disconnect in their Spanish.
correct.
And I'm not sure how to characterize that, but one of them learned maybe somewhere else. Didn't he concede that?
Correct. He did give the impression, he did testify that Hernandez Serrano appeared to lack education, that he used a lot of slang and had a different accent. And his motive, moreover, was always to confirm that Hernandez Serrano understood his rights and not to trick him. And this was exemplified.
And I understand that, and that's a very fair point. But let's go back to your previous sentence, which
Okay.
is he concedes that, I think you said the accent and the slang weren't as apparent maybe as they might have been. The meaning. Do we consider that in determining whether or not the appellant unequivocally, does that modify or color the word unequivocal?
It shows, it goes to to Sergeant G's testimony that he felt that the way Hernandez Serrano said made him feel that Hernandez Serrano was not truly understanding the rights that were being conveyed to him. And so then he asked the follow-up question, is that what you want to do? And Hernandez Serrano, and looking to the context of whether he unequivocally invoked his right to remain silent, Hernandez Serrano did not unequivocally evoke. He simply wanted to answer questions of which he knew. And this, for example, after he said, Sergeant G responded with, you don't want to say anything? And instead of saying no, Hernandez Serrano said, well, what am I going to say if I don't know anything? Later on, after Hernandez Serrano expressed that he was willing to answer questions, Sergeant G asked, yes, you're willing to answer questions? And Hernandez Serrano replied, questions, but what about?
What if this officer, hypothetical, didn't know Spanish, and you have a dialogue that is developing, and there's some exchange that either has some Spanish in it and might be an unequivocal invocation, but the officer doesn't speak Spanish. Is there, when we say a reasonable officer, who is that officer?
A reasonable officer would be someone who can, based off of his knowledge and experience, interpret what the suspect or defendant is actually, what the suspect or defendant means in making certain statements or asking certain questions.
So the law doesn't require, moving back here, the officer to divine the intent from words or accents or slang. At most, it requires the other end, which is, okay, that might not have been as clear as I want. Let's revisit it until it is clear on both of our levels.
Correct, so long as a reasonable officer could have believed that the defendant did not unequivocally invoke. And the evidence from the suppression hearing, viewed in the light most favorable to upholding the trial court's ruling, shows that a reasonable officer could have believed, under the totality of the circumstances, that Hernandez Serrano did not unequivocally invoke his right to remain silent. And
So if there is a language barrier, if the person being interrogated is is not perfectly understood by the officer, what burden does that put on the officer, and how does the trial court view that, and how should we view that?
I think if there is a language barrier, which I don't think there was a language barrier in this case, I think there was a barrier as to what the rights were that Hernandez Serrano had and whether he wanted to unequivocally invoke them. I believe that if there is truly a language barrier and the officer does not understand, I think the trial court would be within its discretion to consider that in ruling on the suppression motion. And
Now, Mr. Hernandez at the suppression hearing, to counsel, of course, argued that was an unequivocal, yes, I'm invoking my right to remain silent.
correct, but we have to view.
But
I'm sorry.
then it would be up to the trial judge to take all the evidence into consideration to determine whether that meant yes.
Absolutely, Your Honor. And here we have sufficient evidence that Sergeant G acted reasonably and genuinely in interpreting the remark. And moreover, and back to
So Sergeant G just didn't know what meant, because his next question was, you don't want to answer anything, right?
yes, but Sergeant G's concern was that Hernandez Serrano did not truly understand what his rights were, and that was shown because Hernandez Serrano did not seem concerned whether he could remain silent. His concern was, am I going to be able to answer these questions? And that's what he was willing to answer questions, but he wanted to be able to answer questions that he could answer. And Sergeant G even mentioned that they were going to discuss his alleged identity theft and said, okay, those are the questions I'm going to ask you. And Hernandez Serrano responded with, those I can answer. And so the facts of this case are sufficiently analogous to the facts of State v. Carter, in which the Arizona Supreme Court held that the defendant's statement that he did not want to say anything was actually in context an avowal that he did not know anything.
Counsel, Judge Howe asked your colleague a question that I just want to ask you to view. Have you read or seen any authority, common authority, interpreting in any of our 50 states?
I have, I'm sorry?
As an unequivocal invocation of one's constitutional right to counsel.
I have not, and I think the fact that the judiciary has defined it for its office and that other state agencies may have shows that it's inherently ambiguous. And even despite whether a government agency or an individual may have interpreted to mean yes, in essence. We have to look at this case through the lens of what a reasonable officer could have believed based on Sergeant G's interpretation.
It really does depend on the context and the inflection. I mean, there's a big difference between saying "uh-huh" and "uh-huh."
Correct. Absolutely, Your Honor. And unless this court has any additional questions, we respectfully ask this court to affirm.
Thank you, counsel.
Thank you.
Counsel?
Your Honor, I'd like to touch a couple points. Unless I heard incorrectly, Mr. Serrano couldn't testify as to what "uh-huh" meant. He wasn't going to get on the stand and testify, give comments of the word "uh-huh." So I believe, if I heard correctly, that's not what he could have done.
Mr. Serrano?
Well, Hernandez Serrano, I apologize, Your Honor.
Oh.
Additionally, the idea...
Well, why couldn't he?
Well, he
If he chose to.
well, correct, but he didn't. So he couldn't have explained there because he didn't take the stand. That's what I meant.
Okay.
In addition to the reasonable officer standard, now it's indicated in here, it says that the test for whether a suspect's invocation is sufficiently clear is an objective one. They apply the standard of what a reasonable police officer in the circumstances would understand to be an invocation. So the state here is indicating that the officer had so many experiences, different experiences, a law enforcement agent, speaks Spanish, had been an investigator for a number of years, was the only officer that was the one that would translate from Spanish to English. Even if we take all that, in the motion to suppress transcript that your honors have, and I'm sure I've reviewed, he answers a question with the word "uh-huh." The state asks him a question. The state puts him on the stand. Investigator Guerra's on the stand, and the state asks him a question. I don't recall what the question is, but I do recall his answer. It was "uh-huh." There was no clarifying question after that. They assumed it was an "uh-huh," and they just proceeded to the next question.
Thank you, counsel.
That is showing that Investigator Guerra knows what "uh-huh" means.
Thank you, counsel. Your time is up.
We'd ask the court to vacate the sentence and judgment in your honor and remand to the trial court for a new trial or further proceedings consistent with your opinions.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and issue a decision in due course. We're going to stand at recess until the next argument, so your counsel, please come up. We're going to remain on the bench, however. Thank you, counsel.
Thank you.